we're witnessing a seismic shift in American legal and financial history. In the past 48 hours, Donald Trump's comprehensive legal strategy to shield his business empire has suffered a complete and catastrophic failure. This isn't merely a procedural setback or a temporary delay. We're looking at a situation where a presiding judge deployed extraordinarily harsh language. Words like frivolous, baseless, and unworthy of the court's time, to describe legal arguments presented by one of the most recognizable figures in modern American history. But here's the critical element that mainstream coverage is missing. The asset seizure mechanism has already been activated. Properties that have literally defined Manhattan's skyline for generations are now facing potential liquidation. The question we must answer is straightforward yet profound. How did we arrive at this unprecedented moment? Why did every emergency legal intervention fail so spectacularly? And what does it signify when the judicial system, the financial industry, and even specialized bond companies simultaneously refuse to provide relief? The answers to these questions reveal something far more significant than one individual's legal predicament. They expose whether wealth and political influence can still override the fundamental principles of law itself. Let's establish the timeline with precision, because the sequence of events is absolutely essential to understanding the magnitude of what's unfolding. Several weeks ago, a New York state judge issued a final judgment against Donald Trump for what the court characterized as persistent and repeated fraud spanning more than a decade. The financial penalty? $454 million. This isn't a negotiable fine. It's not a settlement subject to spin or reinterpretation. This is a court-ordered disgorgement, a legal mechanism specifically designed to strip away profits obtained through fraudulent business practices. Trump's legal team responded immediately with emergency motions seeking to halt enforcement while they pursued appeals. This is standard legal procedure in civil cases. But what happened next was anything but standard. Within mere days, those emergency motions were categorically rejected. The presiding appellate judge didn't simply deny the request. She systematically deconstructed every single argument Trump's attorneys presented, describing them as procedurally improper and lacking any legal merit whatsoever. The real devastation was buried in the technical details. Trump's legal team constructed their defense on three foundational arguments. First, they contended that enforcing the judgment before exhausting all appeals violated his constitutional right to due process. Second, they argued the bond requirement exceeding $400 million was impossibly excessive and specifically calibrated to destroy him financially. Third, they characterized the entire prosecution as politically motivated persecution orchestrated by the New York Attorney General. The court didn't merely disagree with these contentions. The ruling essentially stated that these arguments ignored fundamental legal principles that apply uniformly to every defendant in New York State, completely regardless of wealth, status, or public profile. Now we arrive at the portion of this story that should genuinely alarm anyone paying attention to how justice functions. Trump's lawyers acknowledged in official court filings that they contacted over 30 separate bond companies, 30 distinct financial institutions whose entire business model revolves around risk assessment and providing surety bonds for civil defendants. Every single institution refused, not because of political pressure, not because of media narratives or public opinion. After conducting independent reviews of Trump's assets and the fraud judgment against him, they each determined the financial risk was simply unacceptable. Consider the implications for just a moment. These are sophisticated financial entities that routinely provide bonds for defendants owing tens or hundreds of millions of dollars in civil litigation. This is their daily business. And they uniformly declined to back Donald Trump. Without that bond, New York law is unambiguous. The Attorney General's office gains immediate authority to begin enforcement proceedings. That means identifying assets, filing liens, and preparing for outright seizure. According to sources with direct knowledge of the case, the AG's office has already compiled a detailed inventory of Trump properties throughout New York, including 40 Wall Street, Trump Tower on Fifth Avenue, and numerous other significant commercial holdings. The estimated combined valuation ranges somewhere between $600 million and $1.2 billion, depending entirely on valuation methodology and who's conducting the assessment. Here's where the situation becomes almost darkly ironic. Trump was found liable for fraud specifically because he systematically and deliberately inflated these exact property values when dealing with banks and insurance companies over many years. So when his legal team now argues these properties are sufficiently valuable to cover the judgment and should therefore be protected from seizure, the court's response is essentially, "We literally just ruled that you've been systematically lying about these valuations for over a decade. Why would we suddenly believe these figures now?" This isn't political targeting. This is what happens when the gap between claimed asset values and actual market reality becomes undeniable and publicly documented. Let's examine the legal mechanics here, because this is where most coverage fundamentally misses the point. The bond requirement isn't arbitrary punishment for wealthy defendants. It exists for one specific, crucial purpose: ensuring that if an appeal ultimately fails, sufficient assets remain available to satisfy the judgment. Without this mechanism, defendants could spend years filing appeals while quietly transferring assets offshore, restructuring ownership through shell companies, or moving properties into family members' names. By the time appeals are finally exhausted, nothing remains to collect. The judgment becomes meaningless paper. New York's appellate rules are explicitly clear on this point. If you want an automatic stay of enforcement during appeals, you must post a bond equal to 110% of the judgment amount. In Trump's case, that calculation meant approximately $500 million. His legal team immediately characterized this as excessive, unconstitutional, and specifically designed to target him personally. But here's the data point that completely undermines that argument. New York courts grant stays with reduced bonds or without bonds in only two very specific circumstances. First, when defendants can prove they literally lack assets to cover the bond. Second, when there's compelling evidence the judgment itself rested on fundamental legal error likely to be overturned on appeal. Trump's team attempted to argue both simultaneously. They claimed he couldn't possibly secure a bond of that magnitude, while simultaneously insisting his properties were worth far more than the judgment amount. The logical contradiction is immediately apparent. The court certainly recognized it. This is where financial reality becomes impossible to ignore. Bond companies don't operate based on political ideology or media narratives. They function on cold, mathematical risk assessment. When defendants apply for surety bonds, these companies conduct exhaustive due diligence. They examine every claimed asset, verify ownership structures, review existing liens and debts, and most critically, they conduct completely independent valuations. They don't accept the defendant's representations at face value. They hire their own appraisers, forensic accountants, and legal experts. In Trump's situation, over 30 of these companies executed this exact process, and every single one independently reached the identical conclusion. The risk was prohibitively high. What does that actually mean? It means when these financial professionals analyzed Trump's assets, incorporated the fraud judgment, examined legal precedents, and ran their risk models, they determined there was unacceptable probability they would suffer financial losses. Either the assets weren't worth what Trump claimed, or the likelihood of successful appeal was too remote, or both factors were in play. This wasn't coordinated conspiracy. This was the market rendering its verdict through the invisible hand of independent financial analysis. The judge's ruling addressed this reality with devastating clarity. She noted that Trump had been found liable for fraud specifically because he habitually and systematically overstated asset values. His own expert witnesses during trial admitted under cross-examination that his financial statements contained inflated figures. The court had reviewed thousands of pages of documentation showing a consistent pattern of valuation manipulation spanning years. So when Trump's post-trial arguments relied entirely on those same inflated valuations to claim irreparable harm from enforcement, the court's patience evaporated completely. Let's address the constitutional argument, because this reveals something fascinating from a legal perspective. Trump's team argued that enforcing a judgment before appeals are complete violates due process under both the U.S. Constitution and New York State Constitution. On the surface, this sounds compelling. How can you seize someone's property before they've exhausted every legal avenue to challenge the judgment? But here's what that argument deliberately ignores. Due process doesn't mean endless delay or consequence-free litigation. It means you receive notice of charges, a fair opportunity to defend yourself, the right to present evidence and cross-examine witnesses, and access to the appeals process. Donald Trump received all of that. The original trial lasted months. His lawyers cross-examined every witness. They presented their own experts. They made every argument they wanted to make. The judge issued a detailed 100-plus page ruling, explaining precisely why Trump lost. That's due process. The bond requirement doesn't undermine due process, it protects it. If defendants could automatically delay enforcement for years simply by filing appeals, what happens to plaintiffs, or in this case, the state seeking to recover fraudulently obtained profits? They wait indefinitely with no guarantee of ever collecting a dollar. Meanwhile, the defendant has every incentive and opportunity to conceal assets. The court pointed out something that should be obvious but apparently needed explicit statement. The bond requirement has been upheld by New York's highest courts repeatedly over decades. It applies uniformly to every civil defendant who loses a money judgment and wants to appeal. Corporate executives, small business owners, real estate developers, investment managers, everyone faces the same standard. Trump wasn't being singled out for harsher treatment. He was being held to exactly the same standard as every other defendant in his position. The only difference was the judgment size, which reflected the scale and duration of fraud the court had found. And here's the crucial detail. Trump's team never actually argued the underlying legal standard was unconstitutional. They argued it was unconstitutional as applied to him specifically, because of the dollar amount and his unique circumstances. In other words, they were requesting special treatment, not equal treatment. The court saw through that immediately. So what are the broader implications? Consider the employees working in Trump-owned properties. If major buildings are seized and sold, hundreds of jobs hang in the balance. Think about small businesses operating as tenants in Trump properties: restaurants, law firms, retailers. Their lease agreements become uncertain overnight. Zoom out to the broader New York commercial real estate market. If multiple Trump properties hit the market simultaneously through forced sales, that's a massive supply shock in an already challenging environment, struggling since the pandemic fundamentally altered office space demand. Perhaps most significantly, this ruling sends a message to wealthy defendants everywhere. The courts are losing patience with endless delay tactics. When you lose a civil fraud case after a full trial, and you can't post the required bond because the financial market won't back you, enforcement begins immediately. No amount of political rhetoric or media attention changes that equation. So let's crystallize the three most critical points. First, the court system has conclusively rejected every legal argument Trump's team presented, using language that signals complete exhaustion with delay tactics. Second, over 30 financial institutions independently refused to back Trump's assets with a bond, a market verdict on his credibility that no legal argument can overcome. Third, the asset seizure process has already begun, with real properties and real businesses now at genuine risk. The fundamental takeaway? When the legal system and the financial market both say no simultaneously, wealth and power cease being shields. They become irrelevant. Does this moment represent justice finally catching up? Or does it establish a dangerous precedent? The answer to that question will define how we understand the relationship between power and accountability for generations to come.